In your case. So the next case set for argument is State of Ohio versus Jarvell Henderson, case number 29090. The State of Ohio, the appellee, has waived oral argument. So we will be hearing this morning arguments from Attorney Buchanan on behalf of Ms. Henderson. We've read the briefs and are prepared to proceed if you are, Attorney Buchanan.
Thank you, Your Honor. May I please support? I do have the privilege of representing Jarvell Henderson. He is the appellant in this matter. As indicated by the court, the government has waived their oral arguments. I will not save any time for rebuttal and attempt to answer all of the panel's questions. The Jarvell's argument here is that text messages still make a contract. Now, the facts of this case were that prosecutor text messages an offer to Jarvell's trial counsel. Jarvell's trial counsel has a conversation. Jarvell indicates he's going to accept this offer, and then there's a period of time that elapses, and the prosecutor, in Jarvell's opinion, unilaterally revokes the offer. Jarvell then files a motion with the trial court saying, please specifically enforce the contract.
Isn't it the court's discretion as to whether or not it accepts of the agreement, though?
It is the court's discretion, and in this case, the court didn't say, I'm not accepting the plea agreement. It said, no, I'm not enforcing the offer. And there is a difference, because there is a difference between the court saying, I don't like this offer, and as the trial court does play a role in facilitating plea negotiations and whether or not to accept them, the court didn't state that on the record. In addition, what concerns Jarvell is that one of the things that would take this out of the executory contract area here would be that Jarvell detrimentally relied on the government's offer here, because in essence, he was in Summit County Jail. He had not posted bond. He accepts the offer, so he is saying, I'm going to admit to this killing, I'm taking responsibility for my actions, and I'm willing to spend the next, perhaps my entire life in prison with the eligibility of parole after 25 years. So there would, I would indicate to the court that the trial court did not take into consideration whether or not that is detrimental reliance on Jarvell's position, which would then give Jarvell the opportunity to perform. Or the court could have said to the parties, listen, let's put the offer on the record, and then the trial court could say, in my opinion, I don't really like this offer. Now, the trial court can't do that.
I want to back up.
Sure.
And let's assume, for the sake of argument here, that the text messages are part and parcel of contract. Was there an offer, or was it a conditional offer? You're calling it an offer as though it was in fact an offer, and I'm trying to reach back in my contract law. Wasn't it conditional?
I would say, Your Honor, Jarvell says that it was not a conditional offer, and because to use the first year law example is that you've got a caterpillar, and as soon as the offer is accepted, it turns into a butterfly. And the government, through the text messages, said, I make this offer, and said, in exchange for your guilty plea, you'll plead to 25 to life, and that will be it. And they use the trade, in essence, the trade usage of criminal defense, that vernacular. And then Jarvell's trial counsel says, yes, he's accepted the offer. So at that moment, Jarvell's position is that, yes, the offer was made, contract is for I've assented to this contract, the condition is that I have to perform, and that performance is me going to the court and pleading guilty. And that's why.
Was it the condition that the victim had to okay it, or the victim's family had to okay the offer?
Well, there's nothing in the record that indicates whether or not the victim's family did accept or did reject or made any position on whether or not they accepted this offer.
There's something in the record that was part of what you call the offer, 25 to life, 15 to life, forever, but I have to run it by the victim.
Sure, and even if that were to have occurred, the offer was unilaterally revoked, and it wasn't subject to that condition. Because, in essence, the text messages do state by the prosecutor, Jarvell's got a bad record. This is too good of an offer. I'm revoking it. And that's a difference between the condition precedent wasn't fulfilled, because the offer was revoked before Jarvell could have even had that condition precedent occur, or the prosecutor would have even notified the victim or the victim's family. And so Jarvell's position, again, is that it was a unilateral withdrawal of the offer, and that's part and parcel of why the trial court erred in not specifically enforcement. Now, Jarvell's first request by this court is to reverse the trial court and specifically enforce the plea agreement of 25 to life. However, this court has stated, and I want to make sure I get the case cited right, it was State v. Phillips, 2016, Ohio 8094, held that a guilty plea waives those pre-trial errors. Judge Hensel, you did concur in that judgment, and that did distinguish a case by the 8th District that was State v. Padilla, which is 2012, Ohio 5892, which did stand for the proposition that the trial court does play a role in the negotiated plea process. So that is why Jarvell is raising the two assignments of errors. One is plea was not knowingly, intelligently, voluntarily made, and two, that the trial court erred specifically performing it. The basis for Jarvell's second assignment error of the not intelligently, knowingly, voluntarily made is that how could it have been? Because from his position, he accepted a 25 to life offer. And the next offer that is ultimately accepted is 35 to life. So there is, the court did go through the criminal rule 11 colloquy and did ask Jarvell all the required questions. So the position that Jarvell would say, not necessarily that there's a bright line rule here, but I accepted a better offer. And usually we wouldn't have any proof, but we can at least indicate for the record that there is some indication that an offer was made. In fact, the government agreed that the offer was made because in their brief in opposition to the specific performance motion, the prosecutor wrote, and I quote, "That specific offer is no longer on the table." So the offer was made, and there's no denying that by the parties. The problem that the court said was that Jarvell did not perform it and did not come to the court and plead guilty.
Well, your client may have accepted a better offer, but he didn't plead to the better offer.
And Jarvell's position would be, I wasn't given the opportunity. Because the offer that was
He
given...
didn't have to plead.
Correct, yeah, there's no requirement that he plead, and the plea has to be knowingly, intelligently, voluntarily. But he did, at least in his mind, have accepted an offer. He just couldn't perform his end of the bargain, and he was trying to do so. And if you are in the Summit County Jail and you're being held without bond, the only way that you can effectuate that is to have the court bring you over and then start to begin to perform. And all those steps, Jarvell would indicate that those all lead to detrimental reliance on Jarvell's point, and that would give him the ability to perform that. The second option that Jarvell would prefer this court to do would be to reverse the trial court and then have his plea withdrawn and then order the trial court to actually have a hearing in regards to this plea agreement, to actually say, have the government and Jarvell's trial counsel come in and say, okay, was this offer made? And to clear up the record. Because it's not a perfect record. And that's
Was there
because
a motion to withdraw the plea filed?
there was not a motion to withdraw the plea. There was a motion for Jarvell to specifically enforce the plea agreement. And that's the method by which Jarvell raised that in the trial court.
Was there an email from defense counsel accepting the plea offer?
It was through text.
There was a text?
It was through text, correct. So and that was the supplement to the motion to reconsider the motion to specifically enforce the plea agreement. The prosecutor makes the text message offer. Jarvell's trial counsel accepts the offer, and there's a period of time that goes by. And that period of time is not delineated. And that's why I think that's a reversible error, is that this court should permit the trial court to say, okay, how much period of time had elapsed? Because I think there would be a factually specific difference if the prosecutor sends a text and then a minute later revokes it, versus a prosecutor sending an offer through text, a week goes by, is notified that it's been accepted, and then, after a period of time, then unilaterally revokes that offer. Because then the prosecutor knows that the Jarvell was intending to plead guilty. They have that in their information.
In revoking the offer, was there any indication that it was because the victim's family did not approve of it?
There was none. The only text messages indicate was that Jarvell has a bad record, and that's why we're revoking the offer. And so Jarvell's position is that's a unilateral revocation. The government is free to make a bad deal. And in this case, they did it, and they admitted it through text messages. And Jarvell said that they admitted they made a big deal. I took the deal. Please let me take the deal. The trial court then stepped in and said, I do not have to enforce the agreement based upon the 4th District case that the trial court relied upon. There is a 10th District case, State v. Johnson, which is 1981, Ohio App, Lexus 10183. And in that case, the 10th District Court of Appeal held that, quote, an offer once made and accepted by the defendant should not be unilaterally withdrawn by the state. I have not found anything that has overruled that case, and that would be Jarvell's position. This was a unilateral revocation and not a failure for them to fulfill a condition precedent going back to our contract principles. Because as an executory contract, it can be revoked any time before Jarvell performs or he begins to perform. Jarvell's position is he began to perform. And in this context of a criminal defendant who's admitting to a killing and saying, listen, I did it, I'm accepting responsibility, and I have the possibility of life in prison with eligibility of parole only after 25 years, the steps that he takes mentally, the steps that the court take by either ordering the defendant from Summit County Jail and that the court's calendaring this for a plea, those all lead to indicate that if since Jarvell was being held without bond, that those indicate that that is him relying to his detriment. In addition, I would have asked the trial court to get his jail phone calls, because if he, as we all know, the jail phone calls are recorded. So after the acceptance of this offer, if he picked up the phone and said, Mom, I'm taking the deal, Dad, I'm taking the deal, XYZ, I'm taking the deal, that he knows it's being recorded. That's an admission of guilt. And I think that would include his detrimental reliance as well. That fact was not explored at the trial court level, so again, I think Jarvell, in this case, that the court should reverse the trial court, and first of all, Jarvell would prefer you specifically enforce the plea agreement, because that would save him 10 years on his sentence. In the alternative, he would ask this court to reverse, find his plea was not knowingly, intelligently, voluntarily made, and then order the court to have a hearing in the matter for whether or not to specifically enforce the contract, or excuse me, the plea agreement, because then the court will have all the facts in before it, and then that can be a more full analysis, because it's a very fact-intensive, and because it revolves around detrimental reliance, in the criminal context, the admission of guilt is, I think, relying to your detriment.
If we were to find for Jarvell's in his favor regarding this request for a hearing, the trial court just indicated that there was no enforceable plea because under Criminal Rule 11F, it wasn't stated in open court. So does 11F just become of no import if you're allowed to go? Do you understand what I'm saying?
I do, Your Honor. And to answer the question, it does still have import, because in this case, the trial court could have had said, what was the offer? Because the arguments that the parties were making was not that no offer was made, was that no agreement has occurred. Now that's a very big difference, because if the trial court comes in and says, listen, what was your offer? And then they place it on the record. And the trial court then has the opportunity to say, I like it or I don't like it, I approve or I don't approve. I mean, that's what the trial court role is, and the case law supports that. So in this case, again, what had happened is Criminal Rule 11, that's where it becomes very, very important, because that's where the trial court says, okay, what was the plea? Because otherwise, if the prosecutor makes a statement and the criminal defendant relies on it and then has the ability to just revoke it, then you've got a bigger problem with Criminal Rule 11, because then a lot of faith is being lost, and it's a race to the courthouse. And if you're being incarcerated or you're being held without bond, that's not a good position to be in. Because how, in essence, the attorney has to pick up the phone and say, Sheriff, I need him here now. And that creates a little bit more of an issue. So as far as having a hearing, that's what the hearing would be for, would be to apply Criminal Rule 11 and let the trial court be a part of the process. Jarvell is not saying, hey, the trial court has no position in this process. Jarvell is saying that the trial court never had the opportunity because the argument was no agreement was made. That's different than no offer was made. Parties agree that an offer was made, and I think that needs to be more fully explored and the facts placed on the record. And with that, I will answer any of your questions by the panel.
There are no other questions, so thank you for your presentation today. The court will take this matter under advisement as well. Issue its decision. The clerk of courts will mail a copy of the court's decision on the day it is released to you. And these are also posted, as you know, on the Supreme Court of Ohio's website. So thank you very much for appearing in argument today.
Thank you, Your Honor.